Have you ever been in a situation where you wished you could just hit a giant pause button on life? Well, in the legal world, that button actually exists. We're going to break down one of the most powerful and fascinating tools a court has, the legal emergency brake.
So let's set the scene. Imagine there's this historic park in your town, a place everyone loves, but a developer's about to tear it down. The bulldozers are literally parked at the gate, engines ready to start at dawn. You fought for months, but it feels like time has just run out.
Is it over? Is there anything at all, that can stop that irreversible damage from happening? Can you legally slam on the brakes at the very last second? Well, the answer is a resounding yes. And that legal emergency brake has a very specific name, the preliminary injunction. So let's dive into exactly what this thing is, how it works, and why it's so important. Okay, here's the official definition from Rule 58 of the Rules of Court. It's an order that a court can grant before a final decision is ever made. It tells someone to either stop doing something, like stop the bulldozers, or in some cases, it can even force them to do something. But let's cut through the legalese. The absolute best way to think about a preliminary injunction is as the court's giant official pause button. When a judge hits it, everything freezes in place. So what's the whole point? Its main job is to preserve what's called the status quo, which is just a fancy way of saying the last peaceful situation before the whole fight started. It stops someone from causing irreversible harm and making the whole lawsuit pointless. I mean, what's the point of winning a case to save the park if it's already been turned into a concrete lot? But, and this is super important, it's temporary. It is not the final victory. Now, you can probably guess that a power this huge, the power to stop someone in their tracks without a full trial, is not something the court just hands out lightly. You have to run a very tough legal gauntlet to get one. And the bar for this is incredibly high. Just listen to this quote from the legal expert Willard Riano. Any hint of doubt or dispute on the asserted legal right precludes the grant. Think about that. Not just solid doubt, any hint of doubt can be enough to get your request denied. So to get past that, you have to prove three core things. First, and this is the big one, you need a clear and unmistakable right. Not a potential right, not a maybe I have a right, but a clear one. Second, you have to show that this right is being seriously invaded. And third, you have to prove an urgent need to stop what's called irreparable injury, damage that no amount of money could ever fix later on. Okay, theory is one thing. But let's see how this clear right test actually plays out in a real courtroom. We're going to look at a case where things got a bit murky. All right, so in Yniaz versus the Court of Appeals, you had a classic land dispute. The person asking for the injunction, the applicant, said, hey, this land is mine, here's my tax declaration to prove it. But then the other party walked into court holding an official Torrens land title, which is basically the gold standard for proving ownership. So which one of those sounds more clear and unmistakable to you? Yeah, the court agreed with you. Injunction denied. The ruling was that a tax declaration, while it's some evidence, creates doubt when you put it up against a formal land title. And remember that quote, any hint of doubt is a deal breaker. So they failed that first crucial test. No clear right, no injunction. Okay, let's try another one. This case involved a company, ACY, and the Bureau of Customs. They had a contract. But buried in that contract was a clause that said the Bureau could revoke the contract for cause. Well, a dispute happened, and the Bureau did exactly that. They revoked it. ACY immediately ran to court and asked for an injunction to force the Bureau to keep the contract going. So, what do you think happened? You got it, injunction denied again. The court's logic was simple. The company couldn't claim a clear and unmistakable right to continue the contract because the contract itself gave the Bureau a clear right to end it. Their own agreement worked against them. So we've seen just how tough it is to get that pause button pressed. But what about the flip side? What protects people from having their projects or their businesses unfairly frozen in place? Well, the system has some really important safeguards built right in. First, for super urgent situations, there's an even faster, more temporary version called a TRO, or temporary restraining order. A judge can issue one that's only good for 72 hours, just to stop the bleeding and force a quick hearing. But here's the kicker. A TRO has an absolute maximum lifespan of 20 days. On day 20, it automatically expires. It just
vanishes. It's designed to be a short-term emergency fix and nothing more.
The second huge safeguard is the applicant's bond. To get an injunction, you have to put up a sum of money with the court. Think of it like a security deposit. Why? Well, if the court later decides, you know what, this injunction was a mistake, and the other party lost money because of it, this bond is used to pay for those damages. It's the court's way of saying, if you're going to press this pause button, you better be right, or you're going to pay for the trouble you caused. So we've looked at the rules, the impossibly high standards, the real-world cases, and the safety nets. So let's zoom out. What's the big picture here? Why does all of this matter so much? Here's the most important thing to remember. A preliminary injunction is not about winning the case. It's about making sure there's still a case left to win. It's about preventing an outcome so catastrophic that no final judgment could ever make it right. It's about making sure that historic park is still standing when the judge finally makes their decision. And this whole thing really brings up a deep, fundamental question for our justice system. The preliminary injunction sits on a knife's edge, right? It's constantly trying to balance this urgent need to stop immediate, irreversible damage against one of the most sacred rights we have, the right for every person to be fully heard in court before a decision is made. So the question for all of us to think about is, how does a legal system get that balance just right? Thanks for tuning in.